Okay, everyone, welcome to the Module 4 live session for the contracts course. This meeting is being recorded for the benefit of your classmates who couldn't be here so they can watch it later. And if you would like to watch it again before you take the quiz, for example. Our topic this week is the statute of frauds. We're also going to be talking about fixing drafting error and legalese in contracts. Let's get started. So your reading for this week was in the textbook, chapter 6. Did anybody take the time to read chapter 6? How do you feel about this textbook? Do you like the textbook? Any thoughts about the textbook? Okay, not yet. Adrian says I have nothing to compare it to. Okay. I actually think it's a very good textbook. I was in the process of writing a textbook about, I don't know, maybe 12 or 13 years ago, but I got so busy doing other things. And this was in 2008. And then the market crashed that fall. And I never did, I already had like a potential deal with Pearson Publishing to write a business law textbook, and there would have been a chapter on contracts, but I never did get to finish that project. But I do like this particular textbook. I think it is very good. So you've also been asked to read the statute of frauds provision in the restatement of contracts. Jody, what is the restatement of contracts?
It's a secondary source to follow, for the judges to follow some kind of guideline.
Okay, what's another word for a secondary source? I actually have one right here. This is what we use when I was in law school. This is Corpus Juris Secundum, which is Latin for the body of law, second edition. It's a treatise. It's a treatise.
That's right.
Yeah.
It's treatise. I always forget because I'm not just used to thinking secondary source.
Yes. Yeah, when I was in law school, we didn't have fancy internet sources. We had to go into a dusty library and read this. And the only reason that I actually have this is the Nevada courts were getting rid of some of their old textbooks. And for old Lang Syne, I decided to just get a copy of Corpus Juris Secundum. It's got 50 different volumes. But yes, the restatement second of contracts is a treatise. There's a restatement of torts, a restatement of property. There's a restatement for conflict of law issues when two different states' law are at issue in a contract. For example, if I live in Nevada and I've entered into a contract with a company in California, and that contract goes to court, for me it'd be a question about whether California law applies or whether Nevada law applies. And then you would go to the restatement for conflict of law to resolve that. So yes, the restatement of contracts is a scholarly treatise. It is not a primary source of law. What is a primary source of law, Adrian?
That would be like what the judgments are, the Supreme Court judgments, cases. You can find it in Lexis. Oh, sorry.
Yes. Yeah. Cases.
Yeah. Okay.
C. What is the other primary source of law? Starts with an A. No, it starts with an S. I'm sorry. Starts with an S. Cases are primary. Statutes. Statutes is the correct pronunciation of that strangely spelled word, Jody. Statutes are written by Congress or your state legislature, and they are a primary source of law. The U.S. Constitution is also a primary source of law. Even though we see some politicians in the past who tried to ignore it, or maybe because they didn't have a legal education, they had never read it, which is more likely the case. So, yes, the US Constitution is the supreme law of the land. And what comes under it are federal laws, and state constitutions as well. That's why it's so important in this society to have political leaders who have legal training. Um, yes. So that is why the Louisiana system of law is a little bit different, and that there is a French tradition because Thomas Jefferson, President of the United States, made a Louisiana purchase and bought several states from France. That's how the United States got so big. We bought territory from other people. And because of that, the legal system in Louisiana is still based on part of it is based on the Napoleonic Code, and it's French. That's neither here nor there. The statute of frauds was part of the English tradition, and it requires certain types of contracts to be in writing. There is an acronym that you need to know. Adrian, what is the acronym that we use to remember the types of contracts that must be in writing?
My legs.
Very good, my legs. M is contracts for marriage. In England, there was a dowry associated with a contract for marriage. And, you know, once the bride and the groom got married, the groom got a dowry. And that's a contract that could not be enforced unless it was in writing. In America, we believe in much more freedom. So contracts for marriage are void against public policy here anyway. And a contract for marriage would also be void if it was not in writing to satisfy the statute of frauds. What does the Y stand for, Kara?
Year.
Yes, contracts that can't be performed within a year. Are you going to remember what we talked about today in a year? Probably not. You might remember that we had live sessions in your contracts class, but you're probably not going to remember all the details of what we talked about. So for that reason, contracts that can't be performed within a year must be in writing to satisfy the statute of frauds. And again, the statute of frauds is codified in every state. It is a statute written by the legislature in a code book. Land is rare. Every parcel of land is deemed very special and rare. So any contract for the sale of land, has anyone here ever bought a house or signed a lease, Tina? What kind of was that an oral lease? Was that an oral purchase of your house? What did that involve, Tina? Yes, it was a written contract Yes, where you had to sign it. So any contract for the sale or lease of land must be in writing to satisfy the statute of frauds. Executor contracts. Contracts for the sale of goods greater than $500. That's codified in the Uniform Commercial Code 2-201. And suretyship and guarantor contracts. What is suretyship? Suretyship is when you promise to stand in the shoes of another person for purposes of a debt, liability, or indemnity. So if you buy a car and your mother decides to co-sign it, she is guaranteeing the loan. Yes, Adrian, it's like co-sign. That co-signer has to sign a writing with all the terms of the agreement to satisfy the statute of frauds. Any questions about the statute of frauds?
I have one.
I mean, yes.
So let's say you bought a car and you didn't want to keep up on it anymore and you sold it to someone else. Would that count too? Because they would be taking over the payments?
Yes, it depends on the terms of the contract, but contract for the sale of goods over $500, the automobile is a good, and if it's worth more than $500, that needs to be in writing. And if they are taking over the payments, guaranteeing your payments, that'd be a guarantor contract. So that would also have to be in writing. So yes.
Okay.
Any other questions? See, the statute of frauds is still enforced every day, so it's a very important concept. So let's talk about our module 4 assignment. In this scenario, Jill and Will are independent contractors. They have completed technology projects for people and businesses. They have not sold parts because they did not want to have to collect sales taxes or deal with the paperwork. In the past, their carefully selected customers have been great. Collection of bills has not been difficult. They preferred not to use written bids or contracts. Jill and Will have changed their minds due to customer needs. They have sought advice from your supervising attorney, Mary. They have even decided they will sell some bigger ticket items. Jill and Will understand from their own research, contracts where they sell over $500 of goods will require a writing, but they want more up-to-date and accurate information. Mary, their attorney, wants you to do a survey of recent cases and articles on the statute of frauds to make sure that she has an up-to-date basis for legal advice. Okay, so this is a research memo. Here's what you need to do, and your memo should just answer these questions in order. Find a recent case in Lexis Advance or Fast case on the statute of frauds. For that case, you need to do an IRAC, issue, rule, analysis, conclusion. You do need to give me a brief description of the facts of the case so that I can understand how the case is relevant. 2, find a recent article about the statute of frauds in the Rasmussen online library. 3, find a legal blog, you can Google this, regarding the statute of frauds. And 4, find the statute of frauds in your home state. Minnesota has a particular statute, Minnesota stat, whatever number for the statute of frauds. So whatever state you're in, search that state on Lexis Advance, type in the word statute of frauds, look under, your state statutes, and then put that in your memo. Any questions?
I always have questions. So
Yes.
I wrote my paper already, but for the flow to look good for the research part, for the IRAC at the beginning, like I did the facts and I went, anyway, I put the IRAC at the bottom of the whole thing just so the flow of the actual research paper would look okay. Is that okay?
That's fine.
Okay. And then when we're quoting number 4, our statute of frauds in our home state, we're just quoting what we found, right? We're not like summarizing, we're just quoting.
Yep.
Okay, all right. That's what I thought. Thank you.
Really? Yeah, all I
Oh.
need is a statute.
Okay, then I'm good. Thank you.
And remember, that statute needs to be in Blue Book format. And here we use the Indigo Blue Book and it's online. So yeah, you could just give me the statute. All right, any more questions about how to do the Module 4 assignment? The best way to approach these assignments is just to dive right in there and go in order. Do number 1 first, do number 2 first, do number 3 first, do number 4 first. Okay, we have a discussion forum in Module 4. And the issue is using legal articles or blog posts. Find an example of legal complexity that's very hard to simplify. As you know, a lot of legalese is very difficult. Again, for several reasons. One of the reasons why, and I think this is getting toward contract language, but judges also use a lot of complicated language in their opinions. And statutes also have complicated information also. Again, that's because of the tradition in the law that was brought over from England. And over the years, we have simplified the way that we write. Think about how you talk when you're sending, an Instagram message, or when you're sending you're sending somebody a text message and you're using 2 words, TTYL, talk to you later. So we obviously are moving towards simplification of complex language. When I was a kid, it was Burger King. Now it's called BK. When I was a kid, it was called Kentucky Fried Chicken, and the food was better than 2. Now it's called KFC. So you can see we're moving toward a much more abbreviated and simplified way of communicating. And ideally, it would be great to reflect that in the law to make it more, accessible to people, so that lawyers and judges are not the only ones that can read a contract and understand it. So in this discussion forum, be sure to just jump on the internet, find an example of some complex language, cite the reference, explain what makes the example complex and difficult to simplify. Here are some examples that were given. In the event of the contingency of the failure to fulfill the order for 1,000 widget occurs, buyer may, at the buyer's option, obtain cover, substitute goods from another supplier, or otherwise act so as to obtain the aforementioned goods that were not delivered. Jody, what would be an easier way to say that?
Take out the whereas. Even, are you talking the first one or the second one though?
In the event of the contingency, that first
Okay.
one, that one.
Okay, I would say take out if there's a failure of the order not being properly filled, the buyer can cover with other goods, conforming goods. That's just a quick summary up, quickly.
Yes, and it sounds like they're just talking about the UCC provision on cover. They could just write that in the contract. In the event that the seller fails to fulfill the order, the buyer may exercise any remedy under the UCC. That'd be perfectly acceptable. And that way, if there's a breach of contract and they end up in court, the judge can right away say, oh, well, you have the option of using any remedy that the UCC provided. Granted, the UCC applies anyway. If it's a contract for the sale of goods, the UCC applies anyway, which is why this language is even more redundant than ever. So you're in a contract under the UCC, the buyer already, based on the law applies everywhere. So the UCC applies anytime you have a contract for the sale of goods, regardless of what the contract says, the UCC applies. So you don't need to say the buyer can cover or that the seller can cure. That exists already, it's redundant. This whole thing is redundant. The easiest way to just say is if you've got a really good lawyer writing the contract, any remedies available under the UCC would apply, period. It would be helpful if they're going to change something for a specific due date. That would be okay to say. That if the buyer waits for 30 days and the seller hasn't cured, then the buyer can cover. Okay. But just to, say that the buyer has every remedy that the UCC offers, that gets the job done without all this unnecessary, in the event of a contingency, All right, good. So let's look at the second example of legalese. Whereas the buyer has failed to promptly notify the seller of the intention of the buyer to refuse to either pay the price or explain failure to pay, and has failed to indicate non-acceptance of the aforesaid goods and the reasons thereof for said failure to indicate, seller shall refuse to stop deliveries and shall continue to invoice them until further notice. This phrase, refuse to stop deliveries, what's wrong with that, Tina? Refuse to stop deliveries. Could you say that more simply?
I would probably say that all deliveries would be stopped for future contracts.
Refuse to stop. If you refuse to stop, then what do? You go. So what they're saying is no, it's a double negative, and that's why it tripped you up. Adrian, what does it mean to refuse to stop if you don't stop?
That they're still going to deliver.
Yes, it's a double negative. That's why it's confusing. Refuse to stop means go. That means the seller will continue to deliver and continue to charge until the buyer gets notice of the intention not to pay. So yeah, double negatives should be avoided. Avoided, 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 avoided. Why is this here? Again, because that is part of the English tradition. This whereas and heretofore, that's old English. And all of that should be simplified. That's the modern trend. Okay, so in this discussion forum, after you make your post, take a look at your classmates' posts. Look for repetition, too much complexity, double or triple negatives. Remember, two negatives cancel each other out. That's like a positive. Two negatives cancel each other out. Refuse to stop. Double negatives cancel each other out, and that means go. So if you're looking at that, you want to use short sentences and remove double negatives and redundancy. Here's an example. Dale rejects, denies, and refuses to accept that the promise is contractual in nature. Kara, what does that mean? Dale rejects, denies, and refuses. Are those three words different or similar, Kara? Dale rejects, denies, and refuses.
I would say that they are similar.
That's redundancy. Good. That means you could just say, Dale refuses to accept that the promise is contractual.
I still don't understand why they're like double and triple negatives in legal terms.
Sometimes it's to emphasize, and sometimes it is because Again, America's law developed from England. You go back to the history of how this nation was founded. This nation was founded when certain people got tired of the Church of England and other areas in Europe. They got tired of religious persecution and being forced to follow a certain religion. And there's a deeper history beyond that, because at first in England, everything was about Catholicism. There was a king that wanted to get a divorce. Catholic Church does not allow that. So they had to start the Church of England to allow Henry VIII to get another divorce. So then you have the Church of England. Well, some people don't want to be under the Church of England. So they came to America and to have religious freedom. But what they brought with them was the law that they knew, which was the English common law and the English tradition and the English books and the English culture. So that's how people spoke within the judges in England. That's how they spoke, Kara.
Okay.
And there may be a time when an attorney is making a closing argument in court and he says, Your Honor, my client rejects, denies, and refuses to accept that the promise is contractual. Oh, well, that might be a powerful verbal argument. But when you're reading it and when you're writing it, and you get bogged down, and the movement is to simplify, right? BK, KFC, AMD, whatever, right? Nobody says Burger King anymore. I don't even go there anymore. It's BK. So that's why it's a change over time towards simplification. When back in the day, everything was, how glorious the English barristers and judges could make the law sound so glorious and that only they understood it. Now, the average citizen wants to understand the law because it applies to everybody. So that's the problem. And again, if you're if you're making a closing argument in court, it may be important to emphasize the point that Dale rejects, denies, and refuses to accept, Your Honor, that the promise is contractual in nature. Oh, but when we're trying to read something and get through it and move on, because we don't have a lot of time because the client is paying us and they're paying us by the hour, we want to simplify that. Does that make sense, Kara?
Yes. Thank you so much for taking the time to explain that.
Oh, you're welcome. History is really controlling so many things,
Yeah.
and the law is full of tradition and history. So we are moving forward again to a time when we get rid of all of that, just like the contracts for marriage. They did that in England 500 years ago. We do not do that in America. So the law is moving forward. As it moves forward, we want to simplify everything. TTYL, right?
Yeah.
BFF for best friends forever. BFF. Here's another example of legalese. At that point in time, whereupon, in the event that the goods are delivered, Jill shall pay the price. How could you simplify that, Adrian? At that point in time, whereupon, and in the event that the goods are delivered, Jill shall pay the price.
Well, they could say, when the goods are delivered within the time frame, June shall pay the price.
Yep. You could just say when. When the goods are delivered, June shall pay the price. I would even change the shall to will. I wouldn't even use shall, because we don't use shall in America. Again, that's old English. When the goods are delivered, June will pay the price. So that's why the law is intimidating, fancy words like that. But our whole goal is to simplify, right? Simplify, make it so that our client can understand, right? If we're drafting a contract for the client, do you want to have to read that back to a client? You'd rather just tell the client, look, here's what I've written. when the goods are delivered, June will pay the price. And then your client understands and you're communicating. Because there's nothing worse, Adrian, than two people talking, but there's no meaning being transmitted. Have you ever been in a conversation, two people are talking, or it might even be a lecture, but nothing is being communicated?
That's with my teenage daughter.
Yes, because they're speaking a different language, right? Her
Yeah, oh, yeah.
friends and then yeah, they're speaking a different language, right? So thank you. How would you fix that, Jody?
Sorry, my computer froze up. So, which sentence did you want me to fix? Sorry about that. Oh, shoot. Ah,
Everybody hear me?
I hear Jody.
But nah,
yeah.
it keeps like freezing.
Yeah, mine was too. I thought it's my Wi-Fi.
No, I
That's
think
what
it's
I thought
Professor
at first.
Dove's.
Oh, yeah, because I can hear you guys, but I can't hear Professor Dove.
Oh, she just put in the chat she's still here. So
Okay.
Type yes if you can hear me. Okay, you can hear me?
Yeah.
Okay, awesome. I
Yes,
turned
ma'am.
off, okay, I turned off my video because the video is using extra bandwidth.
Yeah.
All right, thank you. So we will continue on. Technical difficulties have been solved, and we're here simplifying legalese. Number 3, in the event that Jeremy is unable to pay, the contract may be canceled. Jody, how can we simplify that?
If Jeremy is not going to pay, the contract is canceled.
Good, good. You could keep that maybe, because that maybe gives a little more flexibility. It says
Okay.
that the contract could still be enforced, right? He may be unable to pay. The contract may still be enforced because maybe the seller will extend him credit. So that maybe is not equal to is or even will. There's a shade of difference because there's a little flexibility there, Jody. But yeah, if is better than in the event than, right? If is one word, in the event than is 4 words. I mean, an event is like a concert, right? It's the county fair. We don't need that. So as Jody said, if Jeremy is unable to pay, the contract may be canceled. And it may not. Maybe someone will extend him credit. All right, let's look at number 4. If either party shall fail to stop breaching this contract. Tina, what do you see right away? If either party shall fail to stop breaching this contract.
Shall fail.
Huh?
Stop.
It's a double negative, right?
Mm-hmm.
So you would simply erase that. and say, if either party breaches the contract. Double negatives cancel each other out, Tina. So you just draw a line through that and make it, if either party breaches this contract. What do you think, Adrian?
What you said was perfect. That's exactly what I was thinking.
Yeah. Fail to stop. Just that's redundant. If either party breaches the contract.
It really makes it sound like they've been continuously breaching, which obviously they have not been.
Yeah, it's legal. It's bad legalese. Okay. Let's take a quick review of some of the basic grammar rules. Because again, when you're involved in legal writing, you want to make sure that you know the rules of grammar. I mean, gosh, when I was working in law firms, I was dealing with this generation of people who were incredibly well educated in public schools. They knew the rules of grammar backwards. And if I said in order to instead of to, they would look at me like I was crazy. If I did not put a semicolon before the word therefore and a comma after it, I would be sat down in the law firm and somebody would come in and say, let me show you grammar, Catherine. Okay, so you want to make sure you know some of the basic rules of grammar. There's a link down here to a website you can check out. It's the Owl Purdue Writing Lab, and I will send out this slide presentation with the live link in it. We're going to go over some basic rules of grammar. Sentence structure is muy importante, which means very important. A sentence must have a subject and a verb. The subject and the verb must agree in terms of whether they are plural or singular. Here's an example. Bob and Tim is friends. What's wrong with that, Adrian? Why is there an X next to that? Bob and Tim is friends.
Well, first of all, it sounds terrible. And second of all, I was always taught is for one, R is for two or more. So that's how I remember it. I don't really know how to tell you
Perfect.
why it's wrong, but it is wrong.
That is why, because is a linking verb and it needs to agree with the subject. Is when you have a singular subject. Tim is a friend. But when you have Bob and Tim, that's a plural subject and you need a plural linking verb, are friends. Very important. Here's the next rule of grammar. This one's trickier. Neither Bob nor Tim is going to the party, or would you say neither Bob nor Tim are going to the party? What do you think about that, Jody? Which one of those is right? Which one's wrong?
The first one is right. The second one is wrong. It's just the way it sounds.
You're exactly right. Neither Bob nor Tim is singular. If you said both Bob and Tim, that'd be plural. Tim is not going to the party. Bob is not going to the party. Singular. That is why the second example is wrong. Okay, third one. Shamika walked to school, or Shamika walks to school. What do you think, Tina? Which one of those is right? Which one is wrong?
The first one is wrong and the second one is correct.
Yes, Shamika is singular. When you have a singular subject, you add an S to the active verb, and it's grammatically correct. Now, if you had a plural subject, they walk to school, then you would not have to add the S, because when you have a plural subject, you just go ahead and use your active verb. But when you have a singular noun, Shamika, You need to add an S. So if you want more examples of this, try the grammar exercises in the Purdue Writing Lab. They're fabulous. Any questions? Okay, so we have another quiz this week. Is everyone excited? You do have the option of taking this quiz twice. So if you take it once and you bomb it, you can take it again. See how nice I am? So here's the review. The Module 4 quiz is cumulative of everything that we've discussed in Modules 1, 2, 3, and 4. Here is what I think would be helpful to know. We talked about the 3 elements of a valid contract. Jody, do you remember what they are?
Offer, acceptance, and consideration.
Brilliant. That's all you need to have a valid contract. Contracts do not have to be in writing. What is the law that applies to service contracts, Adrian?
I knew you were going to ask me. The restat. Oh crap! I can't think of it. It's like it's literally went out of my head. I was just thinking of it, and I knew you were going to ask me. And it went out of my head.
So
That is,
if the common law applies to everyone, it's common to everyone. The common law is a set of judge-made decisions. So the common law applies to service contracts.
yes.
Contracts, yeah, so that's the difference. So if I hire Britney Spears to come and perform at my birthday party, that's a personal service contract. The UCC would not apply. The UCC only applies to contracts for the sale of goods over $500. Okay, Tina. Jody told us that the 3 elements of a contract are offer, acceptance, and consideration. What is consideration?
Considerations are payment or whatever the seller is getting in return, or excuse me, the buyer
Okay,
gets in return.
okay. What if you and I enter into a settlement agreement because you hit my car and I have a right to sue you for the damages, but we enter into a settlement agreement where you agree to pay me $100 and I decide not to sue you. What is the consideration for that contract?
It's the $100 and the option that you said of not suing me.
Okay, and that's called a forbearance. Forbearance to sue. Anytime someone refrains from doing something they have a legal right to do, that is valuable consideration. So if Bob is a smoker and grandma wants Bob to quit smoking because it's bad for him, and grandma says, Bob, if you quit smoking for a year, grandma will give you $500. Is there consideration for that contract, Tina?
Yes, it's
Okay,
the stopping of smoking and the $500.
exactly. If Bob gives up something he has a legal right to do, that's forbearance, and that's something of value. Okay, Adrian, what is the statute of frauds?
it's the UCC section 2.201. Is that what you're talking about?
No. What is the statute of fraud? It's a broader question. You gave me a very narrow answer. It's a
Oh, you
broad
mean
question.
for it's for written contracts that need to be signed?
Okay, good. Let me get a definition from
Sure.
Jody. Can you give me a definition, Jody, of the statute of frauds?
Yes, I just read it in the module. It's the purpose is to commend the actually say, hey, the ones that are following the guidelines, hey, good for you. But it also points out the ones that are not following the contract rules.
Not exactly. Let me give you a definition. The statute of fraud simply says certain contracts must be in writing to be enforced. The purpose is actually to avoid fraud. You know, we talked the first week, and I think Kara brought it up, the problem with he said, she said, if you don't have a written contract. We don't want the he said, she said problem when we're dealing with certain types of contracts. So the statute of frauds says that 6 types of contracts must be in writing, and the acronym is MyLegs. One provision is for the sale of goods, Adrian, as you pointed out, that's G. But the statute of frauds also applies to contracts for marriage, contracts for the sale of land, contracts that cannot be performed within a year, executor, suretyship, and guarantor contracts. So what is the statute of frauds? It simply says certain contracts must be in writing to be enforced. So let's go to that second question, Adrian. Is the statute of frauds part of this UCC?
Yes.
You got it. There is a specific provision in the UCC for contracts for the sale of goods. But the statute of frauds exists even if you're dealing with service contracts as well. Any contract that cannot be performed within a year. Again, if I hire Britney Spears and I tell her, I want you to perform at my birthday party in 2 years, does that have to be in writing, Adrian?
Yes, it does. And signed.
Okay. Good point. Yeah, even though it's not a contract for the sale of goods, it's a contract that can't be performed within a year. So a service contract that cannot be performed within a year must be in writing under the statute of frauds. If I sell you beachfront property in Alaska, Jody, does that have to be in writing?
Can you repeat it? Sorry, though.
Yes. If I sell you beachfront property in Alaska, does that contract have to be in writing?
Yes, because it's real estate. Any real estate property has to be in contract.
Okay, good. I think you have a good understanding of the statute of frauds. What else do we need to know for the quiz? Kara, what should a paralegal do if she finds an error in a contract?
Highlight it and let her supervising attorney know.
Good, good. Tina, what is IRAC an acronym for? What is IRAC? What does it stand for?
I know. I'm so sorry. I think I went blank. I know what is it? I forget the I. I know it's rule, analysis, and conclusion. The I'm sorry, the I is issue. So issue, rule, analysis, and conclusion.
Perfect. Why do we use IRAC tables in MS Word, like in modules 1 and 2?
It makes it easier to display the information and it flows better.
Okay, and how could it help you if you're a paralegal working on a case?
I think it makes the information more organized and structured and easy to find the information.
Okay, and you might even realize that you need to get more facts from the client to do your analysis, or you might realize that you need to do more research to find a different rule. Okay, Jody, what is the restatement second of contracts?
It's a secondary source of treaties for
Perfect.
judges to follow?
It's not just for judges to follow. It's a treatise for anyone that wants to read about the law. Prisoners, law students, a lot of prisoners are in jail studying the law because they want to figure out how to get out. They might decide to read it, the restatement. Judges, lawyers, anyone who wants to do research and just get a foundational understanding of some issue in the law. And then when you want to get more specific and get an on-point recent case, that's when you would turn to Lexis. But anyone could read that treatise, a paralegal, a law student, a prisoner, a pro se wife in a divorce case who's representing herself if she needs to know something. So it's like an encyclopedia, it's a treatise. It's not just for judges. It's for anyone who wants to research legal information and get good summaries of topics. So it's a treatise, like you said. Tina, why would you use Lexis Advance or Fastcase?
It's more up to date, and it has any overturned judgments or rules, I guess you'd say. I'm probably not
Okay,
saying it right, but I would choose to
good,
use that over Google.
good. It's a premium service. Is it free, Adrian? Is Lexis Advance free?
No, it is not. It's very expensive.
Yes, it's a premium research service that practicing attorneys, law firms, paralegals, and students, pay for. In your case, the school, pays for it or gets an arrangement so that we can access it. It's a premium legal research service. Okay, we talked about last week the UCC. Be sure you know what the seller's duties are under the UCC and what the buyer's duties are under the UCC and what the seller's and the buyer's remedies are under the UCC. Any other questions about the Module 4 quiz? Okay, we are almost at the top of the hour. So thank you all, Kara, Adrian, Jody, and Tina, for taking the time out of your schedule to attend the Module 4 live session. And this is a graded live session. So to get credit for the live session, you must submit the correct answer to the live session question. And for those of you watching the video at home, please submit the correct answer to the live session question. And the question for this week is, what are 3 remedies the buyer has under the UCC? You can Google it, you can use it, you can look up your notes from last week. Just need the correct answer. What are 3 remedies the buyer has under the UCC? Please be sure to submit the correct answer by Sunday, August 1st. Any questions? Please be sure to submit all of your Module 4 assignments by Sunday, August 1st, the written assignment, the quiz, the discussion forum posts, 2 posts, and the answer to the live session question. See you